Welcome to This Explainer. Okay, today we are going to completely crack the code on testamentary succession. If you're prepping for your exams, you already know this topic can feel, well, incredibly dense. It's packed with interlocking sections and complex case law. But don't worry, we're going to clear the fog right now. Together, we'll build a high-yield study roadmap that distills all these heavy concepts into clear, actionable takeaways. You're going to walk away from this knowing exactly what makes a will legally ironclad.
So let's dive right in by fundamentally changing how we think about a will. Just forget the idea of a dusty, static document locked away in a vault somewhere. Instead, I want you to picture a will as a legal time capsule. Why? Well, it all comes down to a vital legal concept called ambulatory. This literally means the document remains completely fluid, alive, and alterable for as long as you are alive. It doesn't get locked in until the very moment of death.
And here's our roadmap for today. First, the legal time capsule. Second, who plays by these rules. Third, capacity and free will. Fourth, the 4 essential characteristics. And we'll wrap up with number 5, a case law cheat sheet.
All right, moving right into section 1, the legal time capsule. Now, diving straight into the specific wording for Section 62, it perfectly captures the ambulatory nature we were just talking about. The rule here is incredibly clear. A will is liable to be altered or revoked by its maker at literally any time, provided they are competent to dispose of their property. The power is entirely in the creator's hands. To make this stick, there are 3 strict time capsule rules you've absolutely got to memorize. Number 1, you must pack this capsule when you have a sound, competent mind. 2, you have the absolute right to open it, tweak it, or just throw the whole thing away whenever you want while you're still alive. And 3, the seal on this capsule, it's only broken upon your death. That is the exact specific moment it triggers and takes legal effect. Okay, moving on to Section 2. Who plays by these rules? Let's break down the jurisdictional dividing line, because examiners love this. Sections 57 and 58 draw a very clear contrast. Under Section 57, these specific rules apply to wills made by Hindus, Buddhists, Sikhs, and Jainas, specifically looking at historical jurisdictions like Bengal, Madras, and Bombay, or generally anything post-January 1st, 1927. But pay attention to Section 58. It explicitly states that these provisions do not apply to Muslims, who are governed entirely by their own distinct personal laws regarding testamentary succession. You really want to keep that distinction sharp.
Which brings us to Section 3, capacity and free will. Section 59 gives us this fascinating checklist. The baseline is simple enough, right? You need a sound mind and you can't be a minor. But the caveats are where it gets interesting. Married women can absolutely dispose of their property. And remarkably, even an insane person can write a valid will, provided, and this is key, they do so during a lucid interval. Being deaf, dumb, or blind doesn't strip your capacity at all. However, if a person is in a state of mind where they just don't know what they are doing, say due to severe intoxication or illness, they categorically cannot write a will. No exceptions.
But here's the catch. Having the mental capacity alone just isn't enough. As outlined in Section 61, the actual process of creating this document must be 100% free of outside pressure. The law is incredibly strict about protecting the true, authentic intentions of the creator.
Think about it. If a will is created through fraud, coercion, or importunity, which is basically relentless, overwhelming badgering, it completely strips away the testator's agency. And if your free will is gone, well, it's simply not your will anymore. The law treats this as a void document. In legal terms, we call this a sham will.
Let's hit Section 4, the 4 essential characteristics.
Definitely memorize these 4 steps. First, the document has to be a legal declaration made by a competent person, following all the proper execution procedures. Second, it must specifically aim to dispose of the testator's property. Third, it has to intend to take effect only after death, not between living people, which, as you know, is called inter vivos. And fourth, its very essence must be revocability. This brings us right back to that ambulatory time capsule concept.
Now, there is a huge caveat for characteristic number 2. The document absolutely must dispose of property. If it just appoints a manager or, say, grants a widow the power to adopt a child, but doesn't actually dispose of real property, the courts simply won't view it as a will. This exact scenario was famously demonstrated in the Ram Nath versus Ram Nagina case.
And that leads us to a vital Latin term you'll want to highlight big time, animus testandi. This translates to the necessary, legally binding intention of a testator to actually make a will. You see, the court isn't just looking at the ink on the page. They are searching for the clear, undeniable intent behind those words. Without animus testandi, you just have a piece of paper, not a will.
All right, Section 5, the case law cheat sheet.
You're definitely going to want to take notes on these specific fact patterns because they constantly test the boundaries of capacity and intent. In Ram Nath, a document that was conditional on mismanagement was deemed just a family arrangement, not a will. In Mazhar Hassan vs. Boda Bibi, the court held that committing suicide shortly after drafting a will does not automatically prove mental instability at the time of writing. And in Garib Shah vs. Pache Desai, simply receiving medical injections or a blood transfusion right before signing doesn't invalidate the will, as long as the person's capacity remained intact.
This next case brilliantly highlights the pragmatic side of the law. In Pereira v. Pereira, the Privy Council held that having full capacity when giving the initial instructions to a solicitor is legally sufficient, even if the testator's condition goes downhill and they aren't fully capable of understanding all the complex legal jargon at the exact moment the pen hits the paper. The will survives. It remains valid based on those initial sound instructions.
Finally, as we wrap up our roadmap, let's talk about the actual form and language of the document. Honestly, you might think a will needs to look like some elaborate Hollywood prop, covered in wax seals and heavy legalese.
But actually, the law is wonderfully practical here. You don't need fancy legal jargon, technical terminology, or some rigid format. A will can literally be written in any language. The absolute defining requirement, as long as it's properly signed and attested, of course, is that the intention, that animus testandi, is completely unambiguous. Clarity is king here.
So, as you review your notes and gear up for your exams, I want you to ask yourself a slightly more personal question. When it is eventually time to pack your own legal time capsule, will your true animus testandi be completely clear and unambiguous to the people who have to open it? Because at the end of the day, that clarity is the ultimate test of a well-crafted will. Thank you so much for joining me in this explainer. Study hard, and I'll catch you in the next one.